I'm Drew Stevenson, and this is a lecture for both my administrative law course and my statutory interpretation and regulation class about general statements of policy and interpretive rules under the Administrative Procedure Act, Section 553. Basically, these two types of documents or agency statements that are put out are alternatives to informal rulemaking or notice and comment rulemaking under the APA. We're going to study several cases about this. There's actually a lot of uncertainty in this area of law. So let's dive in here and see what the issue is. So this is a slide with the APA's section B of 553 of the Administrative Procedure Act. That's the basic framework of notice and comment rulemaking. So it says when you're going to promulgate a regulation, you have to provide general notice. You're going to publish it in the Federal Register, or if this is an industry that, let's say, only has one or two companies or market participants, you could just serve them through service process. But in any case, the notice includes a statement of the time, place, nature of the public rulemaking proceedings, reference to the legal authority, the enabling statute under which it's proposed, and the terms and substance of the proposed rule. Our concern here is the next part where in 553B, it says, except when notice or hearing is required by statute, it does not apply to A, interpretive rules, general statements of policy, or rules of agency organization, procedure, or practice, or B, when the agency for good cause finds and incorporates that finding in a brief statement and reasons therefore are in the rules issued, that notice and public procedure thereon are impracticable, unnecessary, or contrary to the public interest. In other words, that's the emergency exception. Let's say you have a public health emergency like a pandemic, and you have an agency like the Food and Drug Administration that wants to do an expedited approval of a vaccine or a therapeutic treatment or something like that. But our focus in the course is going to be on a line of cases about A, 553B, and then A, about these interpretive rules and general statements of policy, where the agency basically gets to skip the process of having a public comment period. In other words, agencies can avoid having to do notice and comment informal rulemaking, or worse, formal rulemaking, which takes even longer and requires very kind of cumbersome trial-like proceedings, by characterizing a policy announcement or directive as a general statement of policy or an interpretive rule. Now, I'm going to give you a classic example of a general statement of policy, which would be an agency announcing how it's going to prioritize enforcement. Like, are they going to go after the biggest players in the industry? Are they going to go after the ones that cause the most harm, or something like that? So announcing how you're going to prioritize your enforcement actions, or how often you're planning to do, let's say, site inspections, is a pretty routine statement of policy. It's a little different if you say announce a general statement of policy that you're not going to bring any enforcement actions against, let's say, companies with fewer than 50 employees or something like that. That has a lot of implications. And interpretive rules are when the agency is actually implementing or enforcing a statute or even one of its own regulations that has an ambiguous provision or clause in it. And they're saying what their working definition with that is. And there's usually no question that the agency would be allowed to interpret it. But a lot of times they could put out their interpretation through notice and comment rulemaking. And sometimes they're skipping that step and just saying this is an interpretive rule and we're invoking the exception under APA 553B. Now, characterizing a policy directive this way can have a lot of implications for, first of all, for whether judicial review is even available for the agencies for that directive, whether parties can immediately bring a challenge to it. And also for, if we do have a judicial review or case, what type of judicial deference will apply, like Chevron deference and so on. Why? Because a general statement of policy or an interpretive rule may not have the force of law. And therefore, we might not actually end up giving it Chevron deference. So at this point in either of my courses where we talk about this, we haven't really talked about different types of judicial deference, so don't panic, but just be aware that what we're talking about in these cases has some far-reaching implications for what happens when somebody tries to take the agency to court. And that concludes our little introductory lecture that you can use to kind of as a preview for the issues in the case, or as a recap at the end of the chapter or at the end of the semester.